Hi guys, AJ here coming at you with some more IP and welcome to week 10. This is the third of our presentation weeks and this week we continue our examination of the various different problematic aspects of patent law. And patent law is one of those IP rights that just really seems to get people hot under the collar. Last week we had a little look at people getting hot under the collar about patent rights fencing off things. So far as biopiracy is concerned, fencing off little bits and pieces of nature. So far as evergreen is concerned, fencing off what would otherwise be easily accessible generic products. This week we move from those kind of considerations to the actual subject matter itself that patents are granted over, and that is the legality and ethics of granting patents over life and life forms, particularly in the early days of the biosciences, where even just isolating a human gene was considered quite an achievement. It was thought necessary that we have patent protection to incentivize more and more of those kinds of inventions that were seen as, of a fairly significant public good nature. It's good for everybody if the biosciences come up with genetic therapies, if they come up with targeted therapies for known diseases. All of this good stuff was thought to be prodded along somewhat by the economic incentive of patent rights. However, as the technology in the biosciences progressed, the viewpoint shifted fairly significantly towards, well, look at the chilling effect that these patents are having on research, on the development of further products, drugs, particularly, that the public should be getting access to. And so now we are looking back at the issue of things like gene patenting and going, well, really, there's not a whole lot about isolating a gene anymore that makes it novel. Where is the inventive step in that, in just isolating a gene? I mean, it's something that can be done in pretty much, most laboratories in Australia. And so we had the revisitation of the whole issue by the High Court in 2015 with Darcy and Myriad Genetics. In that case, you couldn't have really had two more polar opposite parties. I mean, on the one hand, you had all the public interest lobby groups, and you had a cancer sufferer, Yvonne Darcy, asking that, this gene patent held by Myriad Genetics be cancelled. The gene patent in question was over the BRCA1 and BRCA2 breast cancer genes, and what Myriad had done was isolate those genes. They had worked out that a certain mutation from the normal wild type genetic material of a particular gene, the BRCA genes, indicated an extremely compounded risk of certain types of cancer. And what Myriad had pretty much done worldwide is tie up these genes with patent rights and therefore control the testing of breast cancer patients who wanted to know whether or not they were predisposed to these cancers and therefore take preemptive action, perhaps in getting, a radical mastectomy done of the other breast that was unaffected. And the costs for genetic testing, I mean, I've had it done about $1,600 odd, and the testing can only be done by those approved by Australia's licensee to Myriad Genetics. So very, very hotly debated patent that was. High Court ultimately came down on the side of not granting patent rights over that genetic material. They said really what you'd done was isolated the thing, nothing special in that. And really, if you want to be able to grant patents over genes, this is something that the legislature should be making laws on. It's not really the kind of thing that should be up for judicial grabs. So a collective sigh of relief breathed there by many researchers and cancer sufferers across Australia. However, the decision really wasn't the death knell of patenting in the area of the life sciences by any stretch of the imagination. And you are still more than free to patent any number of living and genetic-based inventions, so long as you are not just isolating the entire gene and trying to patent that. So it has set the benchmark fairly low. We know that you can't just patent genes of themselves, but you can certainly patent things like gene therapies, chimeras, all sorts of, cloned materials and things like this. Now you can see we're wandering into the whole area of fiddling about with the human genetic landscape, the human genome. And, you've got some crazy technologies out there. You're getting human genetic material introduced into animals. You have mice growing human ears on their backs. You have pigs growing organs for transplant recipients. So again, an area fraught with ethical difficulty. And this week's presentation is on the whole idea of, well, how do we sell the idea of providing patent protection to these nascent biosciences in order to prod them along? Is it something we should be prodding along, I guess, is the bigger question that begs to be answered. So the presenters this week will go about writing a speech for a minister who wants to introduce a bill that will support this kind of technology and allow the patenting of transhuman technology. Let's see how persuasive they can be and what kind of arguments get put on the table for us to consider. Without further ado, I'll leave it to the presenters this week. If you have any queries or questions on the material from this week, which I personally think is quite intriguing, like I always say, drop me an email, post something in the forums. Other than that, thanks very much for watching, guys. I hope to catch up with you sometime soon in a Zoom, and I'll see you later. Thanks. Bye.